Welcome to Shielded, the podcast dedicated to helping Florida's first responders understand the laws that affect their work and their lives. We bring clear answers, practical tips, and stories to help you when you need it most. If you're a first responder in Florida, this is your playbook. Be sure to check out all of our resources at bicklerlaw.com. I'm your host, Paolo Longo, and I'm here with my partner, Jeff Bickler. At Bickler & Longo, this is what we do. Now let's get into it. All right, welcome back, everybody. Firefighters, as you know, we've always understood how dangerous the profession is, but what we don't see, especially outside of the fire service, is really just how much of that danger is invisible, right? It's cumulative and it's long term. In the past few years, cancer has really emerged as one of the most significant occupational threats facing firefighters, not because of one single fire, one single event, because it's just the repeated exposure to toxic substances over and over and over throughout the course of a career. Rarely you see immediate symptoms, warnings, and especially with the lack of protection that a lot of these folks have that just keep pace with the risk. So in this episode, the first of a multi-part series, I'd like to say 2 or 3, but it could end up being 3 or 4. We'll have to see. But we're going to start talking about cancer within the fire service. This one, we're really going to focus on the why, okay? Why firefighters face the elevated risks that they do when it comes to cancer, what they're repeatedly exposed to on the job, how those different exposures are classified, and what a lot of the new research is telling us about the crazy cancer rates in the fire service, all right? But specifically, because our podcast is a law cast, right, we're going to try and keep it within the context of the law here in Florida, which we have a statute right on point, 112.1816, which actually gives some legal recognition for cancers in the fire service. And it also says that, a lot of these cancers are not random, but they're to be considered occupational in nature. So understanding some of the science behind the exposures is really essential to understand why we have these legal protections and why they matter. So this episode is going to be about education. It's going to be about awareness. And it's going to give firefighters and their families some context, okay, when facing a cancer diagnosis that should be tied to their years of service. As with me as always, my partner, Jeff Bickler, and we have a special guest today. We have Vinny Luzzi on with us. Yay, Vinny. He is a newly minted partner, I am proud to say. Vinny started with us, I think, before the bar exam, right? Technically an intern, and then he passed the bar exam. And for the past 5 or 6 years, he's been doing stellar work on behalf of our clients. And he is a new partner in our firm, and we're very proud of Vinny and the work that he does. So welcome, Vinny, to the podcast.
Well, thank you, Paolo. Thank you, Jeff. Happy to be here. Happy to talk about some very important things that we see a lot.
Yeah. So, Jeff, we'll let you kick it off, right, with some background and some history on the cancer law, and then we'll let Vinny jump in on some of the boots on the ground work that he's been doing.
Sounds good. Well, this is a really interesting problem that in fire service has been recognized really for decades. There's been a ton of medical research that's been funded both at the state and federal level to look into exposure to toxins in the workplace and then the connection to various types of cancer. And as the research has been done, and as the medical evidence has evolved, we're seeing a more and more realistic connection between the job and these various types of cancer. And, that's kind of an interesting question in and of itself, is like, when you think about cancer, what types of cancers are more specific to the type of toxic exposures that we see in fire service, right? So there's always a question around this general idea. Are we just talking cancer as an occupational disease, or is it a specific type of cancer? And so, when this started, I'd say 20 years ago, and back at the, early part of my practice, we had a theory or a sense that we could try to push these cases as occupational disease cases, right, under a standard workers' compensation approach, where we would argue there's a higher incidence of this disease in firefighters than the general population. And that had a lot of potential issues and problems, primarily because of the way that our law is written with respect to occupational disease. But, over time, as we've followed this medical research, we've seen a growing connection because the data is very granular and they're getting more and more sophisticated in terms of what they're able to test for, the types of exposures, and then what types of chemical exposures actually increase the risk of various types of cancer. So it's been really interesting from a legal perspective to watch this evolution. And to the point now where we feel as though, given all these years of medical research, we're at a point where we can try these cases as occupational disease cases. Now, while all this was going on historically, some states began to pass presumptions related to cancer and fire service. And so, as you would think, right, typically the pro-labor states started really aggressively passing cancer presumption legislation. And then that kind of morphed, and we saw even more conservative states begin to pass legislation. So in Florida, there was a long drawn out battle legislatively to try to get something passed. And we ultimately did see Florida pass a cancer bill. And I wouldn't call it a presumption because it really is intended to be an alternative to workers' compensation. I mean, it says specifically that with regard to a diagnosed condition, that as an alternative, you can take this benefit that the Florida cancer law offers, right? And so we passed this legislation in 2019, and we've been watching how that's unfolded over the course of these years so that, we have a pretty good sense now of how the law is applied. There are still some gray areas that we're litigating. And in fact, and you guys know that I'm fairly frustrated about this, there's a bill pending right now that deals with death benefits and intends to specifically cap entitlement to death benefits at 1 year post-retirement. So that's an issue that we've been litigating and successfully, getting benefits for widows of these various cancers after retirement. So it could be a year, 2, 3, 5, even 6, 7 years post-retirement. You have a cancer death, and we've been pursuing those benefits on behalf of these families, and successfully so. But now, because of what's happening in Tallahassee with this pending legislation, there is a threat that those claims will be capped at 1 year post-retirement. So, that's kind of getting a little bit in the weeds.
Yeah, we'll get there, and we'll get there. We'll let you get in the weeds.
And
But when you're talking,
I know, and we're gonna ultimately build up to that. I think the bigger thing, right, for our perspective and what we're trying to do today is really just inform people about the acknowledgement of this as a problem, right?
right,
And the
right.
building sense that, there is real evidence that supports this contention that there's a higher incidence of cancer generally, and very specifically, certain types of cancer that we can show, with data that there is a significantly higher incidence of some of these diseases than in the general public, right?
Right, and when you're talking about the different types of cancers, that's delineated within the statute, right, Vinny? There's a whole list of what is considered to be occupational.
Yeah, yeah, absolutely. And 112.1816, it enumerates all of the cancers that, to Jeff's point, the studies have really demonstrated have a much higher risk in the firefighter population. And so going all the way back to 2018, when the Florida legislatures were passing 112.1816, they looked at these studies. Specifically, they looked at one from 2010. It was the National Institute of Safety, Health, and Occupation that showed firefighters have a 9% greater risk of developing cancer over the general population, but it also shows that they have a 14% increased risk of dying from cancer over the general population. And so the legislature took these studies and said, these are the cancers that we see much higher rates in fire service. And there you go, 112.1816, they list they list these cancers in the statute.
Right, and so once we finally get some acknowledgement from the legislature that, hey, this is an occupational problem, and we're talking about obtaining benefits and getting benefits, walk us through what the actual benefits are that we're trying to, or that we litigate on behalf of our clients.
Yeah. And, really, I think it's important to also take a step back on kind of the history of this, right? Like Jeff mentioned, about 20 years ago, there's these studies that were coming out. I mentioned the 2010 study, which is 16 years ago at this point, but these studies are progressing even up to today. I won't say that there is a ton of scientific research on this topic, but it is growing and more people are recognizing it. There's becoming several peer-reviewed articles and literature demonstrating this not only from the United States, but there are studies in Europe, there are studies in other countries, and they are using
Canada, yeah, Canada.
all of this information to say that these firefighters are exposed to these substances.
Yeah, there's national and international symposiums on cancer within the fire service, right? I mean, Jeff, you've gone to a couple of these things, where you're listening to I mean, world-renowned, medical experts talking about, this is a real problem, and there's
Yeah.
scientific data to back it up. This isn't just,
Well,
this isn't.
no, the Sylvester Center in Miami, they have had this International Firefighter Cancer Symposium. I think it's coming up on 10 years now. I've been participating in that almost since its inception. And the question always from my perspective was, we're acknowledging this issue, right? And you're doing research and clearly there is a problem. Otherwise you wouldn't be concerned about this and doing this research, right? But why are you not taking a position of advocacy that if this is indeed a work-related condition, that it should be treated as a work-related condition and covered under traditional workers' compensation theories? And at the beginning, I mean, I was the only claimant lawyer in the space, right? And those people looked at me like I had two heads. Like, what are you doing here? And I'm like, because it's obvious to me, given what I do, right, that you have acknowledged an occupational connection here. And that if that is in fact the case, there are legal consequences that follow from that conclusion, right? And, after a couple of years and I kept showing up, I finally got these people to start talking to me. And then we started thinking about, okay, legal theories. Yeah, we had presumptions in other states, but I'm only concerned about Florida, right? And I think that began to build momentum that they knew something had to be done legislatively in Florida, right? But this is, again, the legislative fix for an issue like this is often less than desirable. Right.
Yeah, and a lot of
let's,
times, as we've seen and we've talked about in other podcasts, the legislature makes it worse sometimes than not acknowledging it. I mean,
well,
we
it's,
give them a big clap for acknowledging it, but then, they write a law that just, muddies the waters and makes it more difficult, right? I mean, so who's can blame us for being advocates? And just like you said, if all these scientific, studies and journals are coming out and articles and all this stuff coming out about how it's occupational in nature, then naturally there are legal consequences that follow, right? I mean, who's going to pay, who's going to bear the burden of the medical care, of the wage loss, of the death benefits and all those things? I mean, if somebody dies on the job from, a mechanical accident and that's work comp and that's work covered and there are certain statutory benefits that apply to that, then if you're going to acknowledge cancer as a death, then why do we need a separate law and a separate this and a separate that? When it's occupational, it's work related, it should be covered under workers' comp. They get the medical care, and if God forbid somebody dies from this disease, then they get their families get the same benefits that any other injured worker would do.
oh, of course. And, the lost wage compensation is an enormous issue when you're treating cancer, right? I mean, even assuming a recovery, many times you got 6 months, a year, 2 years of treatment, and you can't do the job, it's a real issue. And, the thing that always just kills me is that, we see these death cases acknowledged as a line of duty, right? And everybody gets out, they have these huge funeral ceremonies and processionals, and everybody comes out and says, "Isn't this horrible?" And yes, it's occupational, and everybody acknowledges it. But then there's a disconnect on the legal entitlement, the benefits. I think that was part and parcel of when they were floating this legislation. They wanted to pass something, and they specifically, like I said at the beginning, were outlining alternatives to workers' comp. And how can you have an alternative to workers' comp, right?
When it's
That is,
occupational.
I mean, it makes no sense, and you're essentially bargaining away benefits that you'd be entitled to under Chapter 440, right? And I think that creates enormous constitutional questions and problems, because you're essentially saying to this firefighter who's diagnosed with cancer, we're going to give you a lesser benefit than you would get under workers' comp, right? And you're going to sign off and accept this. So if you take $25,000 at the point of diagnosis, you've waived essentially any right to workers' compensation. maybe without even knowing what you're doing, right?
Right.
And of course, this is one of the things that the firm has been involved in litigating since 2019. We have been successful. The Sienna case is the best example of this, where, the employer took a position that, well, you accepted this alternative benefit, therefore your rights under the Workers' Comp Act have been waived. And we took that up through trial and appeal, and we were successful on appeal for the widow, who could then pursue the workers' comp benefit in addition to this, this other statutory benefit that she's entitled to. So it's an area of, continuing concern, obviously, for the firm, and how we're handling these issues and trying to provide benefits to families when they have a cancer fatality.
So when we were talking about the kinds of benefits, I mean, what are we actually talking about when we say benefit?
Yeah. So your typical workers' comp claim. So you have an injury arising out of the course and scope of your employment. Workers' comp, they're going to be obligated to give you a doctor to provide medical treatment and authorization for any treatment related to that injury. They're also going to be obligated to give you lost wage benefits, either in the form of no duty status, or if you go on light duty status, they have to supplement a difference. For a beneficiary under workers' comp, there's a $150,000 death benefit if the employee dies from that work-related accident. So those are the workers' comp benefits that we're talking about. You shift gears into the cancer bill statute, 112-1816. Upon the diagnosis of cancer, so when the firefighter is diagnosed, they are entitled to a one-time payout of $25,000. They are entitled to reimbursement of medical treatment only out-of-pocket expenses, copays, or deductibles under their employee health insurance plan. And then if you look at the beneficiaries of a firefighter who dies from cancer, they are entitled to a $75,000 death benefit under the statute. And so there is a very big disconnect between the two statutes, because what's a $25,000 lump sum payout when you look at 4 or 5 years of not being able to work at all? And so the difference between that could be hundreds of thousands of dollars in lost wages, but the cancer bill says you get this, and that's it. And so same thing goes for a beneficiary. It's half of workers' comp's death statute, the 150,000. If somebody's spouse dies of cancer from firefighting, they get $75,000. Look, in my opinion, $75,000, nothing to a widow with maybe small children. That's gonna go really fast. And so that is the large disconnect, but those are the benefits that we're talking about when you're looking at it from a workers' comp perspective or just under 112 bill statute.
Yeah, I mean, if a
I
fireman
think,
dies on the job, if he dies in a fire or, has a fatality on the job in some other way, the statute and its $150,000 benefit, I mean, I think that's pretty insignificant, right, as it is for the value of a human life. But then if you die of cancer as a firefighter and it's assumed to be and it's accepted to be occupational, right? Why are they getting treated like second-class citizens and only getting half of the benefit? That's not even sufficient in the first
well,
place, right? I
I
mean,
do
just like you
think,
said, Jeff, and
Paulo, yeah, it's important here to point out that, right, we believe that there's a reading of these statutes where they should be read together, and that the actual death benefit is 225,000. So, our reading of the statute in its current form is that the $75,000 is in addition to the workers' comp death
right,
benefit.
right. I'm not saying that we agree with what they're saying, but this is what we're hearing, right? When we get these cases, Vinny's litigating these cases. These employers and insurance companies are saying, "Well, we paid the 25. That's all you get." I'm like,
We
"No, no, no."
paid the 75, right?
Right, and
And
that's
now
all
we're
you get.
done. And listen, there's a whole issue there too, and that's in part what this pending legislation is intending to address, which is the definition of firefighter in the statute requires that the firefighter be employed, right? So arguably, and some employers have taken this position, the death benefit is not applicable at all if you're not still employed,
Right.
right? But that's not a reasonable way to read that statute. That's the problem.
Yeah, because who's going to be diagnosed while they're still working, right? It's very, very
No,
few, if any.
no,
Nobody.
it makes zero sense. And that's how we've been able to get those death benefits paid to widows, by the way, is we've threatened litigation, we've filed lawsuits, and they've said, okay, you know what, we're going to pay the 75, even though the guy is not technically a firefighter under the definition of the statute anymore, right? again, there's a way to read the statutes in para materia. We read the various provisions together. And the argument is it's 225 because how could you pay half the death benefit for an occupational disease and that be okay, right? $75,000 is just plainly inadequate. And if you're saying this is an occupational disease, you start with the workers' comp death benefit. That would always
Right.
be the case. And
Right. And
the 75,000 only enhances the baseline workers' comp benefit. That's
yeah,
the argument.
and the verbiage of that statute is a prime example of, why you would get folks like us involved in the legislative process to make sure that the statute is drafted in a correct way instead of a statute that ends up passing that ends up, being a feel good for the legislature because they say they can take care of firefighters, but meanwhile, they're not actually getting the benefit that was intended for them in the first place, right? I mean, it's terrible.
I mean, we knew that all the way back to 2019 when they passed this law, right? But there's no input as far as I could tell from anybody that would actually be doing the litigation of these cases. And, unfortunately, all of these ambiguities and all of these issues that require statutory interpretation and cases to be tried and litigated where you have ambiguity in legal language, the only thing you could do is advocate on behalf of a position or a client. And so we
Right, and if the
continue to do
statute was
that.
written better, then he would probably have less of these he wouldn't be litigating as many of these cases, right?
Yeah.
Well,
Yeah. And
yeah.
I mean, look, just because you're a firefighter diagnosed with cancer, that also doesn't mean that you just become automatically entitled to these benefits. There is criteria that the statute lists out that has also caused litigation and has caused problems. So the statute was passed in 2019, and the first sentence of the statute is upon diagnosis. And so that requires the diagnosis to be post 2019. That case actually went to the appellate court over in Volusia County, and they said that this does not have any retroactive application. So step one, you have to be diagnosed after 2019. Step two, you have to be continuously employed by your current employer for 5 years upon the diagnosis. Step three, upon diagnosis, you have to have 5 years, at least 5 years prior to your diagnosis, no use of tobacco products. Then the last step would be that upon the diagnosis, if you leave your employer, you do not go to any other employment that has a high risk of cancer. And so should you meet those 4 criteria of the statute, now you become eligible for these inadequate benefits that we're talking about under 112.1816. But at least you become eligible for something. And that's been, one of the biggest things is that we're talking about as an alternative. So just because I become eligible for this, now I see I can get a lump sum payment of $25,000. I can get my out-of-pocket expenses, my deductibles, my copays. I can get all that paid for. The firefighter, that looks great to a firefighter, because something is getting recognized as work-related. However, as Jeff mentioned, when you sign the paper to receive those documents or to receive those benefits, arguably now you're waiving your workers' comp benefits. And that has also come up in litigation.
Yeah, that's a whole nother constitutional thing too, waiving,
Right.
benefits that you're entitled to
How do you
statutorily without
waive your statutory rights for a lesser benefit without judicial approval, right? I mean, that's essentially a settlement of a workers' compensation case with no judge signing off on it, right? And that's a violation of Chapter 440, very clearly, right? So and again, nobody talked to people that litigate these types of claims when they pass these laws. And so you end up with all of these crazy problems that we have been contending with since 2019.
Well, if they
And
pass
I've
that
seen,
new law if they pass that new law, it'll get rid of a lot of those cases probably, right?
Well, yeah.
It'll end a lot of
I mean,
litigation because
hey,
there won't be any more people that qualify.
we have 2 widows from Dade County that I spoke to this week that literally this legislation could be fatal to those claims. So if it passes into law, we're not going to be able to secure those benefits for those widows.
Unbelievable. What were
Yep.
you gonna say, Benny?
well, no, I was going to say on the waiver discussion that we were talking about, I've seen maybe close to 100 different types of waivers, and every county, every city has a different waiver that they created that forces the employee to sign and check a box that says, I'm agreeing that this is an alternative to seeking workers' compensation benefits. And so there isn't a uniform document, there isn't a state document created by the cities, by the counties to try to restrict the firefighters from staying away from workers' compensation. And that's become a big issue in litigation.
Right, but
100%.
you're having some success seeing obtaining some additional benefits too for them, correct?
Yeah, we've had really good success bringing these cases. So the one thing I will say about the alternative to workers' compensation language that I actually appreciate is it puts us in civil court. It puts us in a circuit civil court before either a judge in the circuit court or a jury. And when I'm able to make these arguments to jury members or to a circuit court judge who may not hear these types of cases, it's met with a lot of compassion. And that's nothing against these workers' comp judges, but they are continuously hearing about, work-related accidents, occupational disease claims, heart disease claims, stuff like that. And so the change of venue, I think, is a good thing. However, I think ultimately the alternative to workers' compensation is negative and hurtful language.
I agree.
Yeah, and I never liked that. I never liked that word alternative to, it doesn't mean a substitute for, right? I mean, it
Well,
doesn't mean a
and that
replacement
raises a
of.
really interesting issue there, Paolo, which is there's nothing available under workers' comp at diagnosis for an occupational disease. And I've been saying this for years. Well, okay, as an alternative to nothing, you get $25,000, right? Because there is no claim in an occupational disease case until you have disability, which is something we litigate on a daily basis everywhere in the state of Florida. But again, poorly crafted legislation, not understanding the legal implications. So, there is an argument that the waiver is meaningless because there's no benefit available at the point of diagnosis unless there's actual disability at the same time.
Right. There's no bargain for exchange on the comp waiver. I mean, I think it gets set aside.
I agree. And, we haven't had to do that yet. I mean, we've been successful, as Vinny has mentioned. He's done a great job on a lot of these cases in a circuit court setting. And we have been able to get compensation for our clients just by making these arguments. But should the law be tightened up? And, that's kind of where we are. And this may actually be a good place to kind of stop our discussion for today. But, can we do something to tighten this law up? Of course, it could be done and should be done. But it requires that the people in positions of power that are making these decisions and revising this law understand what's really happening with these cases. And right now, there's just an enormous disconnect.
Yeah. Yeah. No, I get it. And I agree with you. I think that's a perfect point to wrap up for today. Unless, Vinny, you got some closing thoughts. But like I said, this is going to be the first of many. So, stay tuned and
Yeah, I mean, I think we come back in here and we can talk about specifics, like we talk about the Sienna case. We could talk about any number of cases that Vinny's been involved in, at the circuit court level. I think we can get into more specific detail maybe in the next podcast. And
yeah, and let's get into on the legislative front too, right? What this new bill looks like, and what's going on that. So we'll definitely keep everybody posted as we're,
Absolutely.
As we're knee deep in the legislative session now. So in the meantime, thank you everybody for tuning in. Thanks for what you do and take care. We'll see you soon.
Okay.
Thanks for listening to Shielded. At Bickler & Longo, this is what we do. We've represented thousands of first responders across the state of Florida. If you need assistance, don't wait. Please reach out. To learn more, head over to bicklerlaw.com or email us at info@bicklerlaw.com. You can also follow us on Facebook and Instagram at Bickler Law. And if you found today's episode to be helpful, please share it with a fellow first responder who might need to hear it. Until next time, stay safe and thank you for all you do.